Alok, thank you Vidhi, and thank you all for coming. It was late August 2011. I had gone to Jabalpur for a case. I was getting ready to go to court when I got a call from the secretary to Justice Aftab Alam saying that the judge wanted to speak to me. The judge came on the line and wanted me to meet him in his chamber that afternoon. I said I was out of town and I could meet him the next day. So we fixed up to meet in his Supreme Court chamber the next day. And I kept wondering why he was calling me. I returned to Delhi and went to his chamber at lunchtime. Nothing could have prepared me for what he was going to tell me. I did wonder why he was calling me, but I couldn't have imagined that the request he made was going to be this. So he, without much discussion or small talk or anything like that, he came straight to the point and said he wanted me to represent Kasab in the appeal which had come to the court from jail. I came to know that after the jail petition had reached the Supreme Court, there had been a clamor from some lawyers wanting to be appointed amicus curiae. Apparently, the registrar went to Chief Justice Kapadia and asked him what he should do. So Chief Justice Kapadia, it seems, decided that he would first assign the case to a particular senior judge and then leave it to the senior judge to decide whom he wanted as amicus, how he wanted to go about it. And so Justice Aftab Alam told me that he had decided to ask me, and he hoped I wouldn't say no. My first reaction was that, not having done major criminal appeals for a few years, it's not that I hadn't done criminal appeals, it's not that I hadn't done death sentences, but for a few years past I hadn't done major criminal appeals, and I expressed that inhibition. He immediately said, I'll give you Gaurav Agarwal. Now, who's Gaurav Agarwal? Gaurav Agarwal is one of my most brilliant former juniors. Justice Aftab Alam knew how much I relied on him for anything which had to do with criminal law. He knew that I had asked specifically for Gaurav Agarwal when I was appointed amicus in the Gulberg Society case. And so he completely disarmed me by saying he would be giving me Gaurav Agarwal and that Gaurav would not say, that he was sure that Gaurav would not say no to him. I decided then and there that I would accept the assignment, but in something as major as this, I thought I should take my family into confidence. I asked for a week's time to give him an answer, only because both my children were at different locations abroad and I thought talking to everyone would take time. So Justice Alam said, you don't need a week, take 2 or 3 days. I said, fine. Eid was just 2 or 3 days away, and so when I took leave of him, I wished him for Eid in advance. And Justice Alam said, please come home for Sevain. So I was to go to his house 2 or 3 days later. And so I had to take my decision by then. I came home. I spoke to my wife. My wife is a lawyer. She didn't have any problem. She left the decision to me. She said, think about it and take the decision which you think is best. I spoke to my children at their different locations. My daughter, though not a lawyer, is a scholar who engages with the law, and she wished me best of luck. My son is a lawyer, so there's no problem at all. And then I wanted to take my aging parents into confidence. My father gave me his silent assent, but my mother had reservations. She asked me whether I had a choice to say no. So I reminded her about the time when my father was in service. He was a railway officer, and she always said with pride that my father had never refused a transfer or a posting because he saw that as the call of duty. Of course, in those days, transfers were always in public interest. You didn't have Khemka type transfers. So when I said, this is my call of duty, and so I can't say no, my mother saw the point and agreed. And so I went back to Justice Alam on Eid day and told him that I would accept the assignment. The news was not public for quite some time, till one of my dear friends in the Indian Express felt she shouldn't keep it to herself anymore, and so she broke the story. When the news became public, I received all kinds of queries from the media. One would have thought that those who cover the Supreme Court regularly would be familiar with the idea of amicus curiae. But no. Some asked, will you be defending Kasab? When I said yes, they were shocked. Then some asked, I suppose you will argue only on the question of sentence. I had to explain to them the role of an amicus curiae in a criminal appeal. Because everyone today thinks of amicus curiae only as a neutral lawyer in a public interest litigation where eminent lawyers are appointed, or very learned lawyers being appointed as amicus curiae in matters involving questions of law. Most recent instance being day before yesterday, when Mr. Parasaran and Mr. Andhyarujina were appointed amicus in the matter involving criminal defamation. So I had to explain this. As far as friends and colleagues are concerned, I didn't have to face any hostility. I need to mention this because my counterparts in the courts below, in the trial court and in the high court, did their duty. They were also court-appointed lawyers under far more adverse and trying circumstances. There were no mobs saying this person should not be defended. there was no bar resolution, which often happens, that this person shouldn't be defended. My colleagues at the bar were uniformly supportive, appreciative, and wished me good luck. And so that was most heartening, heartwarming, and I was therefore able to start on a very positive note. Now, the petition which had come from jail, as I told you, was a letter petition. So it fell to the lot of Gaurav Agarwal to go through the record and prepare and file a cogent special leave petition urging all the grounds which could be urged. The petition was drafted and filed, and the matter came up for admission before the Supreme Court sometime in October 2011. I must also mention that I received a lot of well-meaning advice from friends and well-wishers that I should ask for security, that I should change the route of my car every day for the sake of my own safety. And I didn't see the point, because I didn't receive any threat from anyone. I didn't want to draw attention to myself unnecessarily by asking for security. The case came up for admission, as I said, in October. The court, without much argument, admitted the appeal and stayed the death sentence. The bench was Justice Aftab Alam and Justice C.K. Prasad. And Justice Aftab Alam said, and these observations were reported in the press and the media, God knows we will do our best to maintain the rule of law. At times we have to suffer. This is the price we have to pay for maintaining the supremacy of law. I was given time. I asked for 3 months' time, not just to prepare myself, but it would take that much time for the record to come. The state was asked to prepare the record. That was a short time, but a reasonable time which the court gave, and the hearing was fixed for the 31st of January 2012. When I started my arguments, I decided, before I started my arguments, that I would check out of my house, not for any fear, but in order to save time commuting and to avoid being distracted by anything professional or anything domestic. So I checked out of my house and I checked in here, in the India International Center. So I lived here on the days when I argued the case. For the hearings, I argued for about 6.5 days. The prosecution argued for much longer because they wanted to show every bit of evidence to the court. The hearings were held in a very calm and serene atmosphere. The fact that my opponent was Gopal Subramaniam was my greatest advantage, because Gopal is a very fair and courteous opponent. He has himself been amicus in so many important cases. He knew the difficult job which I was performing, so there were no rude interruptions, there was no playing to the gallery, there was no ridicule, and so I was able to argue. I must also mention, I should have mentioned this earlier, I received offers of help from different quarters. On the one hand, there were plain busybodies, including those who had wanted to be amicus in this case because of the publicity which it would give them. So they said, any assistance which you need, please call me, I'm always there. There were also offers of assistance from scholars and activists who had worked on the death penalty, and these were genuine and well-meaning offers. Now it was more difficult to handle those offers because those were persons whose credentials, at least in the matter of death penalty, were far superior to mine. At the same time, I was the amicus curiae. I had been given a co-amicus curiae, and in a court assignment, I didn't think it would be appropriate to officially associate anyone else and have anyone else sitting by my side except my co-amicus, my juniors, and the co-amicus's juniors. Two of the junior lawyers who assisted me are present today in this hall, and their help was invaluable. And so I told the experts on death penalty that I could certainly use the material which they would give me, but I couldn't take any assistance in court. I'll be speaking a little later about my perception of my role as amicus curiae and the criticism leveled at my perception of my role as amicus curiae, because I think when we debate this matter later, we should debate the role of an amicus curiae generally.